The White House is facing a legal battle over its use of an 18th century law in deportations. The president invoked the Alien Enemies Act of 1798 to deport hundreds of alleged Venezuelan gang members with little or no due process. A federal judge ordered the administration to halt the deportations and turn two flights around. But sources tell ABC News the administration made the calculated decision to ignore that directive. ACLU attorney Lee Gelernt argued this case in court on Saturday and joins me now for more. Lee, thanks for coming on. I know you represent 5 Venezuelans that have yet to be deported, but you say the administration defying this court order raises the stakes enormously. How so?
Well, thanks for having me. So we actually represent the entire class of people who are subject to the Alien Enemies Act. The 5 people that you had mentioned are just the named plaintiffs for an entire class. So, we are not saying at this point that the government defied the court order, but we are saying there are serious reasons to potentially think that they did. And so we have asked, last night we filed something at 2:15 in the morning, asking the judge to order the government to file sworn declarations explaining what happened and whether any of the planes defied the court's order. And so we'll see what happens on that front. But on the other front, the bigger front is whether the President Trump has lawfully used the Alien Enemies Act. And we think clearly not. The act could not be clear. It says you must be a foreign government or foreign nation in a declared war with the United States or invading the United States. That has not happened. And so the use of the Alien Enemies Act during peacetime is absolutely not correct. Using the wartime authority now puts us on a very, very dangerous ground.
Lee, the White House insists not only that the administration did not violate this court order, but also claims federal courts have no jurisdiction over the president's conduct in foreign affairs or ability to remove foreign enemies. Border Czar Tom Homan also went as far as to say this earlier this morning.
I'm proud to be a part of this administration. We're not stopping. I don't care what the judges think. I don't care what the left thinks. We're coming.
Lee, what's your response to that?
Yeah, I almost don't know what to say to that. That is really a dangerous comment. And I think everything coming from the administration is dangerous in that respect, that the federal courts have no role. If the administration is going to openly defy the courts, then we are closing in on what people would call a constitutional crisis. Our country is based on the rule of law. The federal courts have always been able to say what the law is. And so this is a real separation of powers question in 2 respects. One is that the administration is thumbing their nose at what Congress has passed, saying you can only use this law if a foreign government or foreign nation, not a criminal gang, but a foreign government or foreign nation is invading or in a war with the United States. But the second way this is raising a fundamental separation of powers question is if a federal court says you are violating what Congress has done, for the administration to suggest that they either can't, the federal courts can't say what the law is, or they're going to openly defy an order, that's a real slippery slope to a different kind of country than we've known.
Lee, a 1948 case upheld then-President Harry Truman's decision to deport a German national after World War II ended. The Supreme Court ruled there that the Alien Enemies Act empowers the president in ways judges can't second-guess. So is precedent on President Trump's side here?
No, we don't think so. The case that you're referencing and that the government's relying on was very different. That was actually about upholding separation of powers. It's that Congress had declared that declared World War II, and then it was up to Congress to say when the war was over. So all the court did is say it's for Congress to say when the war is over. The court made clear in that case, and there are many other cases that say if the statutory predicates for invoking this 1798 Act are not followed, the courts can say so. And so that's all we're doing is saying, look, Congress has said this can only be used in a declared war with a foreign nation or where a foreign nation is invading. The Supreme Court has always said that the statutory criteria can be reviewed by a federal court, and that's all we're asking to do. We're not asking them to second guess what the president's doing. We're asking the federal court to say whether they have adhered to what Congress wants.
And what about the administration's argument that these gang members entering the country illegally in these numbers is an invasion?
So, you can talk about invasion as sort of loose way on the campaign trail, but in court, it's clear that legally, this is not an invasion within the meaning of the law or the Constitution. That Congress meant to say military invasion by a foreign nation or foreign government. And so this is a far cry from what the law accomplishes. I would just say one other thing. We don't think the Alien Enemies Act can be used during peacetime without any invasion or declared war by a foreign government. But even if it could, the second step would be that the law requires these individuals to have due process to show that they're not members of this gang and that they don't therefore fit within the proclamation the president has issued. None of them have had due process. Our five named plaintiffs dispute that they're members of the gang. I suspect we'll see other people disputing it, but of course we can't reach them right now because they've been hauled off in secret and put in a Salvadoran prison. And in fact, the president issued the proclamation in secret, didn't publish that he had done it till a day later. And I would caution people not to just take at face value what the Trump administration is saying. They have a record of constantly overstating who they're detaining. I mean, look at what happened with Guantanamo just in the last month, where they initially said everyone who was being sent to Guantanamo was the worst of the worst. It turned out that these were people with either low-level criminal violations or no criminal violation whatsoever. So, for that reason as well, I think that the president has violated what Congress has said. Clearly, there's supposed to be due process on top of whether the act can be used at all.
So if the administration did defy this court order and is found to have done so, what recourse is there for the judicial branch to hold the executive branch accountable for that?
Yeah, that's a great question. And so, there historically been a variety of ways for a federal court to enforce its orders through sanctions, contempt, but we're not there yet because we will have to get proof that they defied the court order. But the main thing we're going to focus on is trying to get the people back out of that Salvadoran prison because they are in real danger being in one of those horrendous Salvadoran prisons. And I think many people have probably seen the video of how they were treated when they landed in El Salvador. That sort of performative video that seems like the El Salvador government was ready to put out, probably with U.S. Help. We don't know what the U.S.'s role in that video was, but what we would say to the federal court is the U.S. government needs to be ordered to get those individuals out of the Salvadoran prison if they in fact defied the court order.
All right, ACLU attorney Lee Gelernt, we appreciate your time today, Lee. Thank you.
Thanks for having me.